Plus, may I make a small mention at this stage, my lord? The entire investigation which is going on as of now has got virtually no link with the present applicant.
हाँ हाँ, वो आएगा, सब आएगा, इसीलिए तो सुब्बा राव को हम पीछे पड़े हैं। सुब्बा राव आ जाए, फिर देखेंगे आपको। I could have rejected your application. This is fourth pair application. There are no change circumstances.
None of my applications are on merits, my lord.
हाँ ठीक है, चलिए, तो you want it on merits? लिख देते हैं।
I would take one on merits, my lord.
पहला ही दीजिए।
My lords, may just hear me first.
हाँ हाँ, सुनेंगे, आपको सुन के ही करेंगे।
तो my lords, may just hear my arguments and then pass orders on merits, my lords.
या अगले हफ्ते करेंगे जब इनका इन्वेस्टिगेशन।
No, my lords, may pass orders today itself.
ठीक है, बताइए।
My lords, this is a fourth application.
Shri Vishal Vincent Rajendra Daniel submits that case be decided on its own merits. चलिए, बताइए।
My lords, this is a fourth application for the grant of bail, my lord.
जी।
The offences are under sections 379, 120B, 420 of the IPC.
Yes.
Maximum sentence, my lords, in all these offences is not beyond 7 years. The relevancy of this argument I'll bring in the second part of my argument. Now, my lords, the facts of the case are that on the date of incident, a Swift car was stolen. This was a white-colored Swift Desire four-wheeler car. Now, Milids, on the date of incidents, this is said to have gone stolen. And FIR was registered on 13/1/2022. Milids against unknown persons. And the matter was put to rest. There was absolutely no leads in the matter. Thereafter, Milids, what happens? In an offence registered at police station house Dunda Sivni, which is a police station at district Sivni itself. Two accused.
ये कोतवाली में रजिस्टर।
ये कोतवाली में register हुआ है, sir. This is crime number 26 of 2022, registered at PS Kotwali district Sivni. Then another offence was registered in police station Dunda Sivni. And in that offence, two accused persons, who are again not the present applicant, was taken into custody. The names of those two persons are Sohrab, Sohrab, Sohrab. And the second person is Musa, Musa. This was the first crime in which the accused persons were taken into custody. Now, Sohrab and Musa get taken into custody in this matter.
19 of 22.
19 of 22 PS Dunda Sivni. There, they make a disclosure statement which is recorded in the form of a memorandum statement recorded under section 27 of the Indian Evidence Act. At the very outset, I will submit, that all the contents otherwise which do not lead to a discovery are inadmissible under section 27 of the Indian Evidence Act. Now, within this confessional or disclosure statement, as what is colloquially referred to, they give a description that they in fact had stolen all these cars. That is, there were about 4 such open-ended cases lying at police station Pandurna at district Chhindwara, Dunda Sivni at district Sivni, and Kotwali at district Sivni. They say that all these car thefts have been performed by us only. Now, once this disclosure statement was recorded, the police investigation begins, and thereafter, my lords, the alleged seizures begin. Now, my lords, as I had stated at the very outset, that any confessional statement made under section 27 is only admissible to the extent of what discovery has been made in furtherance of information received thereof. Therefore, my lords, the entire confessional statement is inadmissible and has to be cast out from the considerational aspects of this court, because the seizure of the concerned car, even in this case, has not been effected by either Sohrab or Musa or even the present applicant. The confessional statement is the seizure of the car has been done by that accused person who is still not before the court, and that person is Subba Rao. With my lord's permission, may I just read out the contents of the seizure memo?
पहले मेमोरेंडम पढ़िए मूसा का और सोराब का।
पहले मेमोरेंडम पढ़ देता हूँ सर। मैं सराय भीमसेन का निवासी हूं, ट्रक ड्राइवरी का काम करता हूं। दिनांक 5 या 6 जनवरी की बात है, तारीख सही से याद नहीं है। लक्ष्मीगंज प्रतापगढ़ में मुश्तकीन उर्फ केके उर्फ कल्लन ने मुझे और मूसा उर्फ ननकाऊ को बुलाया था। वहां फरमान अली भी मिला। मुश्तकीन उर्फ केके बोला कि तुम फरमान के साथ जाओ, एक कार चोरी करके देने पर 1 लाख रुपए तुमको दूंगा। तो मैं तैयार हो गया। This is the memorandum statement, my lords, which he gives. Now, all the open ends in this case, the most important link being in this case, this memorandum statement is recorded on 22 January 2022. Now, on this day, they say that Mustaqeen had sent them down. That is where I come into the picture on the basis of a memorandum statement. Now, in furtherance of this memorandum statement, they say the cars were gone and handed over to Mustakin's driver, who allegedly took them down from Butti Bori to this place in Andhra Pradesh, where, of course, these two persons, Sangepu and Subba Rao, probably became active.
Yes.
Now, my lord, Mustakin.
Subba Rao is a driver, as per the statements of Sangepu,
Ji.
who took the car from this Bori Bandi, whatever.
Butti Bori.
Butti Bori.
Yes.
To Andhra.
Yes.
So, this Subba Rao is a
no,
common
Subba Rao is. We do not know, my lords, as of now, with all humility.
We don't know, that's why.
Whether Subba Rao. No, but my lords, my only difficulty, and in all fairness, this is off the record, I am in a very difficult position to explain as to why, in an offense of this nature, this matter is prolonging when the investigation is going. That is why I am just relieving myself of my burden. My lords may keep the investigation pending. That is what my submissions are.
I'll relieve you of your burden.
That is what. My only endeavor is, and this is not a half-hearted attempt, this is a wholehearted attempt to get my client bail, depending upon the satisfaction of my lords.
Yes.
Now, my lords, a phone call is, of course, given by the investigating agency to Mustaqeen Kallan. He says, your name has come down in an offense, although in the form of a memorandum statement, you kindly come down. Now, Millets, I am a resident of Uttar Pradesh. I take the first train. I don't apply for anticipatory bail. I don't apply for transit bail. I don't do anything because there is no reason for me to feel threatened. My name has come down somewhere for whatever reasons, I don't know. I went down immediately. They take me into the police station. They take me into custody immediately. Now, the question which is germane over here is, that's the legal part of my argument. I'll complete on facts and then I'll come. Now, Millets, I am taken into custody. And after I am taken into custody, my lords, my memorandum statement is recorded. Now, my lords, the most important question would be, Sohrab in his memorandum statement says कि बुट्टी बोरी में गाड़ी ले जा करके हम मुस्तकीन के ड्राइवर को दे देते थे. He does not say Subba Rao, he does not say Sangepu के ड्राइवर को, he does not say हम एक ड्राइवर को. He does not even give a description कि वो ड्राइवर साउथ इंडियन था या कौन था. He says कि ये ड्राइवर जो था ये मुस्तकीन का ड्राइवर था. Now when
वो उससे क्योंकि पैसा मिलता था,
उससे पैसा मिलता था,
स्वीकार कर रहे हैं कि उससे पैसा मिलता था.
Right. Now, my only consideration which I'm trying to raise before my lords with all humility is that when Mustaqeen was taken into custody, Mustaqeen would have been the best person to answer, भाई आपका ड्राइवर था जो आपने इन लोगों को भेजा. Their transaction was कि you steal cars, you hand it over to my driver, which will meet you at the Maharashtra Madhya Pradesh border, and then from there you take it ahead. Now, after these persons go to Maharashtra border and Butti Bori and they hand it over to Mustaqeen's driver, Mustaqeen would have been the best person to answer who his driver was.
वही तो दिक्कत है, ये लोग इन्वेस्टिगेशन करते नहीं ना.
My only submission before my lords is, now assuming everything, my lord, this is a defective investigation, or this is not even a case of defective, this is a case of a hopeless investigation.
Yes.
To borrow my lords' analogy, if I may take that liberty to use that adjective.
Yes.
My only submission is, my lords, I am being deprived of my personal liberty from the month of March 2021, my lord.
March 21 से आप जेल में.
15/3/2021.
22.
22. So sorry, 22, my lord. Very sorry.
अब एक साल पीछे क्यों देगा?
March 2022. Now, my lords, if my lords will just see, apart from the memorandum station, now if I were to draw an analogy, if my lords, in the universe of this case, in the form of evidence and facts, the prosecution has planets. And the interplanetary space they are trying to fill up with a memorandum statement. That is 99.9% of their case rests upon these long and lengthy explanations which keep coming in the memorandum statement, all of which lead to no discovery.
Yes.
Because the ultimate most relevant discovery in this case was the car in question. That car in question is still being made by Subba Rao, who is not. And I don't question them. My lords is already grilling them. I'm not going to take that liberty. They'll answer my lords on their level. My only humble submission before my lords is, my lord, apart from the memorandum statement, there is nothing in this case which connects me. Now, they say there are bank accounts. And in those bank accounts, I have received some amount. Before they argue, I'll come fair before.
Did you deposited the amount received by you in cash, received by, not you, by those persons, Musa and Sohrab?
Yes.
In cash from your so-called driver, and they deposited that amount in their bank accounts.
That though Sohrab and Musa say that from this driver who met them at Butti Bori, a sum of rupees 1 lakh and then some 50,000 rupees was received, which they took in cash and deposited in their accounts.
Their accounts, yes.
They never deposited any money in my accounts.
Yes.
The prosecution alleges that there are certain bank statements, and those bank statements also, they claim that I have been the beneficiary of some amounts which is about 30,000, 40,000, 50,000, which they've underscored in their charge sheet. Now, my lords, the only thing which I will...
Where from that money has come?
My only submission is,
where from that money has come?
My lords, I'll just bear with me for one moment. Before the burden shifts from section 101 to 106, I cannot be called upon to answer about millets anything and everything against me.
Right.
The circumstance which the prosecution alleges against me must be prima facie incriminating for me to be called upon to answer. That is which we call the initial burden of proof which the prosecution needs to execute. Till they don't execute that burden, I cannot be made answerable for anything and everything. What my submissions are, if my lords will just have even a bare glimpse at my bank account, my lords will see that there are numerous transactions. It is not that I am otherwise a pauper who is sitting with almost 0 rupees in my bank account and all of a sudden I just received 30,000, 50,000 or 1 lakh from somewhere, which will make those transactions per se illicit or questionable. In my bank account, I'm receiving on an everyday basis. I am an ITR, I file my ITRs, I am a business person, all those things are there. Now, after that, if I receive certain amounts, which they allege are from a clandestine operation, which they have no evidence to prove, that link in itself, I do not say might be something incriminating against me, but that will only and only point in the realm of suspicion. For suspicion to take the place of prima facie proof, there is still a big gap, my lords. Right. Now, millets coming, these are the facts of the case. So in a nutshell, what I'm submitting before my lords is there is no legal evidence to connect me with this matter, my lords. They have only recorded, everything is in the form of a memorandum statement. All the explanations and memorandum statements which are inadmissible in law. Now, my lords, the legal question, which I am very sure will impress much more upon my lords than my factual argument. There was a recent judgment, my lords, which got passed by the Supreme Court, rather celebrated judgment on the question of bail. That was, my lords, the case of Satinder Kumar Antil versus the Central Bureau of Investigation. I have it reported as, my lords, 2022 SCC online, SC page 825. May I just pass this down and read 3 paragraphs from my lords? I have taken the liberty to just flag the relevant portion, my lord. Paragraphs 20, 21 and 22, my lord. After having quoted, my lords, the relevant provisions of the CRPC, which includes 41A and which further includes 60A. And 60A is actually a little more relevant in this case. I'll read from there. It says, no arrest shall be made except in accordance with the provisions of this code or any other law for the time being in force providing for arrest. And of course, the provisions of 40 and 41A, those are well known to my lords. I'll read from 21 onwards. Section 41 under chapter 5 of the code deals with the arrest of persons even for a cognizable offense. As arrest is not mandatory, as can be seen from the mandate of this provision. If the officer is satisfied that a person has committed a cognizable offense, punishable with imprisonment for a term which may be less than 7 years or which may extend to the said period, or with or without fine, an arrest could only follow when he is satisfied that there is a reason to believe or suspect that the said person has committed an offense and there is a necessity for such an arrest. Such necessity is drawn to prevent the committing of any further offense for a proper investigation and to prevent him or her from either disappearing or tampering with evidence. He or she can also be arrested to prevent such person from making any inducement, threat or promise to any person according to the facts so as to dissuade him from disclosing said facts either to the court or to the police officer. One more ground on which an arrest may be necessary is when his or her presence is required after arrest for production before the court and the same cannot be assured. Now the relevant provisions. Para 22. This provision mandates the police officer to record his reasons in writing while making the arrest. Thus, a police officer is duty bound to record the reasons for arresting in writing. Similarly, the police officer shall record reasons when he or she chooses not to arrest. There is no requirement of the aforesaid procedure when the offense alleged is more than 7 years, among other reasons. The consequences of non-compliance with section 41 shall certainly inure to the benefit of the person suspected of the offense. Full stop. Resultantly, While considering the application for enlargement on bail, courts will have to satisfy themselves on the due compliance of this provision. Any non-compliance would entitle the accused to a grant of bail. Now, my lords, the legal argument which I'm putting before my lords is, when the FIR was registered, and for all practical purposes, even when the charge sheet was filed, the offences against me are 420, 379 and 120B34. I'll just read out from the charge sheet itself. None of those offences, my lords, have a punishment clause of beyond 7 years. 420 is the sentence, the most major offence against me, and that has got a maximum sentence of 7 years. Now, my lords, when I was called down, when I reached the police station, they say that you've been named in such and such offence. What reasons has the investigating officer recorded in writing in compliance of section 41A, which goes to indicate what transpired in his mind which necessitated the facilitation of this arrest? And if there is no such explanation recorded by the investigating officer, then in light of this Supreme Court judgment, bail would almost be, without impining again upon the discretionary power of this honorable court, whatever the Supreme Court may write,
will be mandatory.
No, I would not use such language. But my lord's discretion is sublime, and I would not transgress to that extent. My only submission is that there would be a certain thrust to the use of the word compulsory when an application is being considered. Now, my lords, what I submit is all said and done. Now, the intent of this honorable court, my lords, is appreciable. What I humbly submit, because I have been, my lords, part of this matter now for quite some time. It appears to this honorable court that this could be a much larger operation than what it seems to be prima facie. Now, my lords, be that as it may, and I hope that the investigating agency succeeds in unraveling all the facts, no matter how deep down they're inside. But, my lords, if the only condition is that for this monitoring or for otherwise this procedure to continue, then, my lords, that can more than easily be achieved by having released me. My only submissions are the strictest conditions may be imposed on me. If assuming my passport is there, I am willing to surrender my passport. If, my lords, an order to this effect may also be passed that if I am to leave the city of Pratapgarh in Uttar Pradesh, I can take permission of their chief judicial magistrate, and then shall I leave the city of Pratapgarh. Since the charge sheet has not been filed yet, where the other accused persons are concerned, I may even be directed to mark my presence before the police station Kotwali Sivni once every month, so that they, apart from having a tab on me, whenever they find these other accused persons, they can require me for any sort of investigation which they do. Those are all my submissions which I'm putting before my lord. Apart from that, also, if they find that I am not complying with whatever notices they are issuing to me, whether under 160, whether under 91, whether under 41A, that they require my presence after bail is granted, they are always at liberty to get my bail cancelled by my lords.
Yes.
Now, my lords, in these circumstances, my lords, I pray that my lords may grace indulgence towards my side and allow my application. Apart from that, keeping whatever the investigation line my lord wishes to, that may be kept open.